0.25.
All right, we are on record today following a petition yesterday for removal of the child. I authorized the petition as well as an emergency removal order. So today is the preliminary hearing required to follow a removal within 24 hours. We have had a bench conference and we'll tackle any comments about that after appearances.
Lee Heights, I'm filling in today for Ariel Berger as lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Jones.
Amanda Jones from the department.
Michael McFarland representing Mother.
Margaret Allison Gaff.
Thank you. Comments about the sidebar, Ms. Thomas?
Your Honor, I believe that Mr. McFarland just stated his client's intentions. We discussed where placement currently is with the LJL, and I believe we're just moving forward with the prelim today.
Yes, Your Honor.
I agree.
Very good. All right. Well, let's do it then. Okay. I understand also from our sidebar that your client would like the petition read onto the record. Is that right, Mr.
That is
McFarland?
true. I've advised her for rights. We're demanding a bench trial, Your Honor, and we would like to have the petition read.
Very good. And then do you know, can you confirm if your client has received a copy of the petition?
She has. She'll be following along as you read it. There is no Native American heritage. I have asked her about that.
Thank you. Any other cases that might concern this child, like a guardianship or custody case?
No, Your Honor.
Thank you. All right, and you have advice for her rights?
I have.
So that's great. Just as a brief reminder, you are entitled to an attorney, which is why Mr. McFarland is here. If you choose to retain your own attorney, you're welcome to do that, and that person would just reach out to Mr. McFarland to get the information about the case file. You have the right to a bench or jury trial on allegations in the petition, wherein the department has to prove those by a preponderance of the evidence to justify the jurisdiction of the court. You've asked for that, and we'll schedule that accordingly. As it relates to the allegations in the petition itself, I'm happy to review those on the record for you, as is also your right. The petition concerns Jamil Gale, born August 31st, 2024 in Adrian, Michigan. The allegations include that Ernest Conway is the father of the child, who is currently found in Wayne County Jail. There are apparently two potential fathers. Mark Keith Washington is also the other potential father, whose address is in Detroit. And then, of course, you are indicated as a respondent parent, Ms. Margaret Gale, and as currently residing in Tecumseh. On the next page, you'll find the allegations required by the statute under the stay-out form, including the allegation that there's been a violation of the statute, as well as the assertion that there are no other pending family division circuit court cases, which we've already reviewed with you on record. The allegations of the provisions of MCL 712A.2b 1 through 6 that are being violated include two. The first is the parent or other person legally responsible for the care and maintenance of the child, unable to do so, has neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, or that you've subjected the child to a substantial harm to his or her mental well-being, or abandoned the child without proper custody or guardianship. The aspect of the statute that's been alleged to have been violated includes the home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of a parent, guardian, or non-parent adult, or other custodian is an unfit place for the child to live. Paragraph 5 indicates the reasons why it's contrary to the welfare of the child for the child to remain in the home, which includes medical personnel expressed concerns for Margaret Gale's ability to provide basic care for the child. Margaret has provided minimal care for the infant, and hospital staff has done most of the feeding and diaper changes. And Margaret has fed the child. He is on his back in his bed with the bottle propped up, and she does not burp the baby after feeding. The infant has been found choking on the formula due to lack of burping, and Margaret does not react to help him. Paragraph 6 includes the reasonable efforts made to prevent the removal of the child include Romenica Charles and Virginia Hickman Hospital staff attempted many times to explain how to take care of the baby, but Margaret fails to provide necessary attention to the care to the infant. Margaret did receive prenatal care with Dr. Smolinski. Paragraph 7 indicates the specific allegations in reference to the addendum. Paragraph 8 indicates a request to authorize the petition and to issue an order removing the child. It was signed and verified by Hannah Trout and Stasia Thomas on September 4th, 2024. The petition was authorized on September 4th, 2024. The addendum indicates addendum to ex parte petition for removal and jurisdiction as respondent mother, and I'll go over that with you since it's indicated on the scale form. Jurisdiction and venue. Margaret Gale is the biological mother of the subject minor, Jamil Rodick Gale. Margaret Gale named Ernest Conway and Marquise Washington as potential biological fathers of the subject minor. DNA testing is requested to establish paternity. The subject minor is not a member of or eligible for membership in a Native American tribe or band. Margaret Gale was asked on September 4th, 2024, and denied that she or the subject minor have Native American heritage. The subject minor is a resident of Lenawee County, Michigan. The subject minor is currently located with Margaret Gale at Promedica, Charles, and Virginia Hickman Hospital. 5, the incident of alleged neglect that occurred in Lenawee County, Michigan. Factual allegations. As to neglect, physical substantial risk of harm to mental well-being, unfit home environment, neglect, and intoxication. Paragraph 6, on or about 9/1/2024, CVS received a complaint alleging neglect by placing a child at unreasonable risk, or category 1, naming Margaret Gale as the perpetrator and baby boy Gale as the victim. Give me one moment, I gotta set up a breakout room for the case. Paragraph 7, there are concerns that Margaret is unable to safely or appropriately care for an infant or any child. The subject minor would be at a substantial risk of harm if in her care, details of which are outlined below. Substance use concerns. Paragraph 8, on 8/31/2024, Margaret presented to the hospital in an unstable state and appeared to be under the influence of substances and or in some sort of mental health crisis. Margaret then tested negative for all substances. 9, on 9/3/2024, Margaret agreed to take a drug screen. Results are pending. 10, Angela reported Margaret does have a history of substance use and has been in substance abuse rehab several times. Mental health concerns. Paragraph 11, there are concerns regarding Margaret's mental health. The nursing staff reported while Margaret was in labor, when the medical staff had to check for dilation, Margaret would cluck like a duck when the exam was being performed. Paragraph 12, Margaret reports that she is currently in counseling with Caroline Mobley and Dr. Parker is her psychologist. She denied taking mental health medication and stated her diagnosis was anxiety and ADD. Medical reports are requested. Paragraph 13, on 9/3/2024, the worker spoke to Margaret's counselor, Carolyn Mobley. Carolyn reports she does have concerns due to Margaret's mental health, homelessness, and substance abuse. Inability to safely parent. Paragraph 14, Margaret reported she received prenatal care with Dr. Smolensky. Records requested. 15, on 9/1/2024, Margaret and the subject minor, the minor subject, were observed at Promedica, Charles, and Virginia Hickman Hospital. Margaret stated at that time she did not know who the father was or what the race of the child was. Margaret stated the fathers are affiliated with gangs but would not provide their names. Margaret reported she does have a counselor with whom she talks with her frequently. 16, on 9/1/2024, Margaret stated she did not have supplies for her minor child. She stated she had not bought the supplies because her parents had promised her that they would buy the car seat and bassinet. 17, on 9/1/2024, Dr. Rafiq stated she would not feel comfortable discharging the minor child home with Margaret because of the concerns noted while they were at the hospital and the lack of supplies for the child. 18, on 9/3/2024, the worker spoke to the hospital medical staff who are caring for Margaret and the minor subject reported the following concerns. A, that the nursing staff has had to provide most of the care for the minor child since birth. The staff stated Margaret would state she was tired, in pain, hungry, or had to use the restroom when they would ask her to change the baby's diaper or feed the baby. B, they found the baby on several occasions lying in the bassinet with a soiled diaper on and him laying on or swaddled in wet blankets or no blankets. They would have to ask Margaret to change the child. The child was also observed with no clothing on. C, staff reported on a few occasions Margaret stated that she had fed the baby, but no bottle was found in the room. D, on 2 occasions, the minor child was observed by staff lying in his bassinet, choking on spit up from not properly being fed and burped. Staff had to wake Margaret for her to react to what was occurring with the child. Margaret continues to feed the baby while he is lying in his bassinet, despite knowing the risks associated with it. E, the minor child was found propped up on Margaret's leg and a bed sheet across his face. The staff member had to instruct Margaret to take the sheet off the baby's face/head. On 9/3/2024, paragraph 19, safe sleep was discussed and a safety plan was established with Margaret. The safety plan was regarding her feeling overwhelmed with the child, asking for support and substance use. 20, Margaret Gale has a 10-year-old daughter who has not been in her care and custody since she was 2 years old. Margaret's daughter has been adopted by her maternal grandparents, Angela and Gordon Gale. 21, on 9/3/2024, the worker spoke to Margaret's mother, Angela Gale. Angela reported Margaret had her older daughter, Ava Gale, in her care and custody until she was 1.5 years old. Angela reported if Margaret did not have the support of herself or her father, she does not believe she would have been able to take care of Ava's basic needs. 22, Angela provided the worker with the final decree of adoption, case number 2021-DR-07-479, State of South Carolina, regarding Margaret's minor daughter, Ava Gale, dated 9/22/21. Margaret did not attend the court hearing. It was noted that Margaret has not had contact with the minor child since July 2016 due to drug addiction, and this condition makes her unlikely to provide minimally acceptable care for the minor child. Inability to provide for the child. 23. There are concerns regarding Margaret's ability to manage financial resources and provide proper care for the child. On 9/3/2024, Margaret reported to the worker she receives $250 daily from her parents, and she currently does not have employment. Margaret stated the barrier of her not buying supplies for her child was her mom stated she would buy them for her, but she did not. 24. Angela stated Margaret does receive $200 daily from her father, Gordon Gale's personal account. 25. There are concerns that Margaret does not have stable housing to provide a safe environment for the child. Margaret stated she and her roommates are moving into a home in Adrian, Michigan with the housing help of Lenawee. She reports they're currently staying at the Tecumseh Inn. 26, on 9/4/2024, the department spoke to Margaret's roommate, Justin Clement. He stated he and his girlfriend, Ann Vargas, bought the baby clothing, a car seat, and a bassinet on 9/3/2024. 27, Justin stated they currently are living at Tecumseh Inn. They are on a waiting list for an apartment. Justin and Ann stated they do not have employment. 28, Justin reports they, quote, rescued, quote, Margaret from an unsafe situation where she was previously living. Justin reported it was unsafe due to it being dirty and the people in the home taking advantage of Margaret. 29, there is no other arrangement reasonably available to adequately safeguard the child. As Margaret reports, she does not have any relatives that live in Michigan. Her only support is her roommates. Margaret could not provide the worker with relative names that would be able to provide care and support for the baby. Statutory citations. 30, statutory grounds for adjudication. Based on the above stated allegations, jurisdiction is proper under the following subsections of MCL 7128.2b. The child is under the age of 18 and A, 1. The child's parent, when able to do so, neglects or refuses to provide proper care, proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, who are subject to a substantial risk of harm to his mental well-being, who is abandoned by his parent, or who is without proper custody or guardianship. And B, 2, the child's home or environment with Margaret Gale by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent is an unfit place for the juvenile to live in. 31, statutory grounds for removal. Based on the above stated allegations and pursuant to MCL 712A.13A9, removal of the child from the respondent parent's care and custody is necessary, and placement of the child into foster care is necessary as all of the following are true. A, custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. B, no provision of service or other arrangement except removal of the child is reasonably available to adequately safeguard the child from the risk as described in subdivision A. C, continuing the child's residence in the home is contrary to the child's welfare. Consistent with the circumstances, reasonable efforts were made to prevent or eliminate the removal of the child. D, conditions of the child away from the parent are adequate to safeguard the child's health and welfare. Relief requested. 1, authorize this ex parte petition for removal and jurisdiction as to respondent mother Margaret Gale. 2, issue an order removing the child from the care and custody of his mother, Margaret Gale, placing the child in the care and custody of the department. 3, set this matter for a putative father hearing. 4, set this matter for an adjudication trial. And 5, take jurisdiction over the child pursuant to MCL 712A.2B1 and 2. Respectfully submitted 9/4/2024 by Anastasia Thomas and Hannah Trout. There is, of course, the attachment as well, signed by, would appear a member of the ProMedica staff as the attending physician, supporting the allegations that were made in the petition. All right, I'm happy to look for a bench trial date for you. I'll just let you know, Ms. Gale, if you change your mind and wish to have a jury trial, you'll need to make that request in writing within 14 days, and that will be in the order as well to remind you. Ms. Thomas, while I'm looking for a date, would you be so kind as to let us know who you'll have to just confirm these allegations and the current situation as it relates to the child?
Thank you, Honor. Miss Amanda Jones would be the one to confirm it, as Miss Hannah Trout signed it on her behalf.
All right, Ms. Jones, come on up to our witness stand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. All right, proceed at will.
Thank you. Miss Jones, can you state how you are familiar with this matter?
I am the assigned CPS investigator.
And what steps did you take in your investigation to draft the petition that's before the court today?
I've met with the mother, Margaret Gale. I have contacted her current counselor, Carolyn. I have contacted her current roommates, Justin. We have attempted to contact the punitive fathers. I spoke with others of the staff from the ProMedica staff at the labor and delivery unit. I've also spoke to Dr. Rafiq, that was the rounding physician for the weekend.
And in your contacts during your investigation, did you learn about the allegations that were contained in this petition?
Yes, I did.
And is it your assertion that the allegations contained in the petition are true to the best of your knowledge?
Yes, they are.
And what are the main concerns for you as a representative of the department in the child's safety and welfare being in Miss Gale's care?
There's concerns that she could possibly not be able to take care of the child fully alone. There's concerns regarding homelessness. Although she tested negative for substances upon her admission, there are concerns regarding substance use and her past substance use. There's concerns about if she will be able to obtain housing, also employment, although she does receive a significant amount daily from her parents. It appears that she has not, until this moment, went and bought anything for the child, and the child did not have any supplies that were necessary to take care of him at her home.
And based on the petition, it seems that Miss Gale was aware that she was pregnant and was receiving prenatal care.
That is correct.
Okay. And as relates to the status of the child, did you ask Miss Angela Gale if her and the paternal grandfather were willing to do something less intrusive than filing this petition, such as maybe a guardianship or a power of attorney?
I did.
And what was their response?
They stated at this time they would be unable to take the child. I did also ask them about any relatives. They stated that they did have her stepbrother, but they were hesitant on giving me their contact information, but they did contact them themselves and text me back and stated that they were willing to take them as well.
And when you spoke with Miss Carolyn Mobley, the petition also indicates that she shared concerns similar to those contained in the petition. And is that true to the best of your knowledge?
Yes, it is.
And can you just, for the record, state who that individual is again?
That is Margaret's counselor.
At this time, does the baby have any special needs that require like intensive treatment or supervision?
No, it does not.
Okay. Where is the current child currently placed?
The child is currently placed with the punitive father's sister in Adrian, Michigan.
Okay. Were efforts made to contact the putative fathers?
Yes, there was.
Okay, and were any of them successful?
No, there were not.
Other than the two that are named, has Ms. Gale provided any additional names as to who might be the father?
No, she did not.
Is it your opinion that based on Ms. Gale's homelessness, lack of parenting skills, prior lack of engagement in parenting her other child, lack of money management to provide adequate housing or care for the child, that the child is at a substantial risk of harm if in the care and custody of Ms. Gale at this time?
Yes,
And are you asking the court to continue its authorization of this petition?
yes, I am.
The other attorney, the parent attorney may ask if there's a recommendation regarding parenting time. Do you happen to have one at this point in time?
We do not, but we will follow, they'll go through the foster care worker and we will follow the policy, and we just request that it be supervised.
Okay. And just refresh our memory, I guess, or even for the record, do you know what policy is for a child of this age for parenting time?
I am not, oh, sure, for sure.
Okay.
Maybe 3 times a week, maybe 2 hours, but I'm not for sure.
Okay, thank you for that. And the recommendation for supervision of parenting time, can you elaborate why that's the recommendation, or what risk would be posed if parenting time was unsupervised?
Just to ensure the child's safety with Margaret, make sure that all of his cares and needs are being met.
Based on your interactions with Ms. Gale, do you have any concerns about her cognitive abilities to understand the child's needs?
It appears that she might, but I'm unsure if she does have any cognitive or if it's just lack of knowledge from not having a child in her care for so many years. But I'm unaware of any cognitive abilities, but she has lacked the knowledge.
Okay. The allegations in here that indicate the hospital medical staff who cared for Margaret reported concerns regarding the child spitting up from not being burped, from the sheets being over the child's head and potential risk of suffocation there. When were those, were those shared concerns with you on multiple occasions or just one time?
They were shared with me once about multiple occasions.
Okay.
I also seen her feed the child and inside of his bassinet while I was there visiting her. She did not pick up the child to feed the baby. She just propped the bottle up while the baby was laying in the bassinet.
Okay, thank you. I have no further questions of this witness, Your Honor.
Cross-examination, Mr. McFarland?
Yes, you said my client is living at the Tecumseh Inn in Clinton, correct?
Correct.
Are you aware that they do have long-term residential stays there?
I am aware that they do, but I don't know if that's what she is in currently.
Then how can you say she's homeless if you don't know if she doesn't have a long-term stay there?
She stated that she is seeking apartment assistance through Housing Help. So, in the best of my knowledge, if they were going to stay there longer, I wouldn't know why they would have to find an apartment this soon.
You inquired of management if she's ever been late on her payments there?
I have not.
Have you inquired of management the type of stay that she has there?
I have not.
Is the apartment physically okay for her and the child?
I have not observed the apartment at this time.
So we really don't know a lot about whether she's homeless or not, correct?
Correct.
You indicated drugs is an issue, yet she took a drug test at the hospital and came up negative, correct?
Correct.
Gave her another drug test according to the physician, correct?
Correct.
You have the results of that yet?
No, I do not.
When was that given?
That was given, I seen her on Tuesday.
And is this something that you mail into someplace or what?
Yes.
I noticed in your petition, it doesn't state whether this is a natural birth or a C-section. it was a C-section, correct?
Correct.
My client was given pain medication. You did check on that, correct?
Correct.
You don't have dates as to when the nurses reported any of these incidents, correct?
Correct.
So you don't know whether these incidents occurred while she was under the influence of the C-section pain medication, do you?
Correct.
What kind of medication was she under?
As far as I know, because I was there when the nurse stated it was some sort of pain medication. I don't know the exact. I know that she asked for it from the nurse when I was there.
Tell us what the side effects are of that.
I'm not a medical professional.
You don't know whether they may dim your ability to parent or not, do you?
No, I do not.
So how do we know that she wasn't under the influence of the meds when these incidents occurred? How do we know that?
Because there was, I'm not sure. I mean, there was a lot of incidents, and
But we don't know the dates of these incidents. So
it was, they just stated to me it was over the weekend while she was admitted.
we don't know how long she was on the pain medication either, do we?
No, I do not.
There's a possibility that she was under the pain medication when these incidents occurred, isn't there?
Your Honor, I'm going to object to this line of questioning. This is argumentative, and he may make these arguments, but believe that Ms. Jones has answered to the best of her knowledge that she's not a medical professional. She does not know the dates of the incidents or whether the incidents could be caused by her pain medication.
Let me rephrase that. I'll withdraw that. So my understanding that you didn't ask the question if she was on pain medication or its effects.
Correct.
When did you first visit her? How many days after the birth?
I visited on Tuesday,
Birth was on what day?
the 31st of August.
Which is what day?
Friday, Saturday, I think.
Okay. Did you provide her any literature as to parent?
Parent
Right, as
what?
far as a newborn?
No, I provided literature of regarding safe sleep.
I don't see in here where there's a statement from a nurse saying that feeding that child in a crib was neglectful. That's not in your report, correct?
It's not neglectful, no, but not burping the child and the child spitting up, causing him to
I
choke.
wasn't, that's not really answering my question.
No.
The only question was about the feeding.
When they expressed that concern to me, they expressed to her that it's best for her to prop the child up so that he knows who's feeding him, so that they can create this bond and that they are able to take the feeding better than just being propped up in a bassinet.
They didn't say harmful, correct?
Correct.
Okay. You talked to my clients as a psychiatrist or psychologist?
I did not talk to the psychologist, no,
Talk to a therapist for her?
counselor.
Counselor. Did you have a release from my client?
I did not.
Did you use a form to get this information?
She signed a release at the hospital for me. I did not send that to Carolyn. I was just checking in to verify that she was in counseling, and she just continued to tell me the concerns.
Okay, we're gonna have to take a recess in order to handle the other 1 o'clock case, Mr.
Yes, sir.
McFarland. So thank you, Ms. Jones. We're gonna take a brief recess on this matter. We'll get back as soon as we can.
Sure.
Or 1, 2, 5. All right, we are back on record. Ms. Amanda Jones, I can have you back up on our witness stand. I'll just remind you, you remain on the road. And you were in the middle of your cross-examination?
Well, can I have court reporter read back my last statement?
No. It doesn't work that way.
It does on TV. Okay.
We're not that technologically advanced. Mr. McFarland.
Fortunately, I just refreshed my own memory. My client indicated that you presented a waiver to her to sign. I think you testified the same, correct?
Correct.
Did you determine if she was still under the effects of the C-section medication when she signed that?
No, I did not.
Did you read the entire waiver to her?
No, I did not.
Did Did you just flip through the pages, tell her this is a waiver and have her sign the back page?
No, I did not. I explained to her what the paperwork does and what I could get from that paperwork when she signs it.
Can you tell us what you told her?
I told her that it was a release of information to get medical records for her and the baby admission to the hospital.
And that was on the very first day you met her?
Correct.
You said it was like a Tuesday?
This is Tuesday.
Nothing further, Your Honor.
Ms. Heisen, questions?
Just briefly, with the newborn, it's policy to have the first visit within 7 days. Do you intend to do that for
Yeah.
mother?
Yes,
And then also, per policy, twice a week for a newborn should be seeing the mother, is that correct?
that is correct.
And then you also know that our local policy may be more frequent for this infant to maintain the bond. Do you know if the funds that mom receives on a daily basis are through a legal instrument, or is it a gift from her parents?
I've gotten 2 answers. I've gotten, it was through a trust from mom, and I've also gotten that it was out of dad's personal account from her mom, Angela.
Thank you, nothing further.
Any redirect, Ms. Thomas?
No, Your Honor.
Any recross?
Just one. She does make $200 or $250 a day. That's substantial. That's sufficient income to raise a child. Would you agree?
It is, yes.
Bert?
Thank you for your testimony. You may return to your seat.
Thank you.
Any other witnesses, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No, Your Honor, we are going to wait for the trial. My client indicates to me that there is no family or other placement where she would like the child.
Ms. Heisen, anyone you'd like us to hear from?
No witnesses today, thank you.
Comments in closing, Mr. McFarland?
Well, Your Honor, we have some large gaps. There is an admission by the worker that my client did have a C-section. She was medicated. We have statements from the nurses, but we don't know whether their observations were from that time frame under which my client was medicated. The worker did see my client nurse the child in the crib, which nobody's at the hospital is indicating that is harmful to the child for just that short period of time. Concern with drugs, the client tested negative for drugs. There were some things that my client alleged to have done at the hospital. I don't know whether this was done while she was in the pain of labor or while she was under the perhaps influence of a controlled substance for the C-section. And the report does not address that, Your Honor. And that's a very important time frame. Would be whether my client is under some type of medication and was impaired because the hospital placed her under medication for a C-section. She's not homeless. She has a place. Appears to be suitable. She's not behind the rent. No testimony to that. No testimony that she's delinquent. She has sufficient funds. Presenting to me today very plausible, reasonable explanations, contributing to my questioning here. I don't see any where we have enough to take for removal, Your Honor. I guess the test would be now, how is she that she's out of the hospital? She's not under any perhaps postpartum or not still under the influence. I'm presuming she's not on any type of medication, how she's performing. So we're asking that the child remain with her until there is a bench trial, which we're asking. We are asking that because this is a newborn, that rather than just 3 times per week at 2 hours per visit, that it be as generous as possible. So the bond between the infant, the newborn, and the mother can not only form, but be strengthened, which is very important during these formative days of new birth. We're asking for a trial as soon as possible.
Ms. Heisen?
Yes, Your Honor, I think that the proofs are sufficient for, has been standard of proof has been met for the prelim, I would ask you to consider for removal that the test is whether there's substantial risk of harm. And I think taken together, all the different incidents in the hospital show us that there is a risk of harm to the child's life, physical health, or mental well-being, and that there really, in this case, is no other arrangement that's reasonably available. She doesn't live, for example, with a family member, and there is a family member who could support her. There is conditions away from the home that, with family, that this child will be able to have all his needs met. So I would ask you to consider that reasonable efforts were made. Medical professionals have communicated to us that as a whole, all of these incidents demonstrate risk of harm to the child. Thank you.
Yes, I'm fine.
Thank you.
Well, for purposes of scheduling, I've secured a final pretrial date for October 1st, 2024 at 9 a.m.
Your Honor,
At that-
may I be permitted to make a closing?
I'm sorry, Ms. Thomas.
That's
Now I
okay.
know what you're gonna say. You go right ahead.
Your Honor, we would just ask the court to find that probable cause standard has been met today, that at least one of the allegations in the petition are true. To the extent to continue the authorization of this petition moving forward. As it relates to the contrary to welfare findings, this court must make to continue the removal. We ask the court to consider the fact that we had a letter from a doctor who works with new mothers and newborns every single day, multiple parents a day. And we received a letter stating that this doctor had severe concerns about this mother's ability to provide for the child, which is outlined in the petition. I think that in and of itself alerts us that there are some significant deficiencies in this person's ability to safely parent a child of this age, specifically the inability to properly feed or hold and manage this child, to the extent that the child was choking on reflux or after being bottle fed. There were concerns about suffocation after finding the child with a blanket or a sheet over the child's head. Those are not within normal limits of a parent who has just experienced a C-section and on pain meds. This rises to the level that medical professionals felt the need that CPS needed to be involved, or that this mother needed additional teaching, and even with that, continued to express its concerns. And for those reasons, I also believe that that meets the criteria that no other provision of service or other arrangement except removal is available to adequately safeguard the child. This would not be appropriate for in-home jurisdiction. And we have found a fictive kin placement pending that putative father component. We may have had relative placement. The issues are not necessarily homelessness or financial abilities, but rather the mother's ability to utilize resources in a proper manner. This mother allegedly received prenatal care and still failed to maintain any materials for the child, such as bottles, clothing, diapers, wipes, all of which the hospital was agreeable to provide. But given the mother's significant financial assets, it's very concerning that she did not plan for that in advance. And we also do consider the history that this mother has with lack of providing care for another child, a history of substance abuse, the way she presented in the hospital. All of those things make us concerned for this child's welfare and the issues that need to continue to be investigated moving forward. So for those reasons, we are asking the court to continue the placement and order parenting time as directed by policy. Thank you.
All right, thank you, Ms. Thomas, and thank you for the outline of the facts in the case. I do agree with you that the requirements, and with the GAL for that matter, that the requirements for foster care pretrial placement have been met for the reasons that you've highlighted. So I'm going to take judicial notice of your argument on that point. I certainly agree that despite clearly significant financial support, this mother did not prepare for the child. Despite the fact that she had access to the advices of a doctor, we did have another doctor who expressed concerns, and we very rarely get an actual letter from a physician in support of a petition. And so that's clearly concerning. So the allegations do seem, on the face of them, I can see Mr. McFarland's argument. That certainly, someone who's been under some drugs may have a few issues for a bit, but I would also further agree with the GAL and the department that despite those things, there should have been a period of time where this mother was able to demonstrate the ability, capacity, or willingness, frankly, to take care of this child under the facts and circumstances that I have before me this afternoon. The fact that she made excuses when it was time to take care of the child, the fact that staff at the hospital regularly found the staff without, or regularly found the child without being changed, without being clothed. They would have to prompt the mother in order to do some basic care things for this child. I mean, this is an infant. This child certainly needs someone to take care of all of those things for it at the age that the child is at this time. We also have the support of her own parents who are taking care of another child for her that she doesn't see. So there's a lot of allegations in here that certainly need to be proven at the trial through verified and credible witness testimony. But based on the allegations that I have in front of me here today, I certainly find that there's a significant risk of harm in relying on this mother to take care of this child, to change it, to feed it, to make sure that that it is able to meet its developmental milestones. Even with the support of her roommates, I would agree also that it's further concerning that she's relying on her roommates who are also in what is temporary housing, according to their own remarks in the petition, to help provide for the child, and that she's relying on this temporary housing when she's receiving, according to her own comments in the petition, $200 a day. There's a lot of concern here about the amount of money coming into the household of the mother and the lack of responsibility in managing that, which certainly gives this court plenty of concern that this child would be at a substantial risk of harm if this mother were put in the charge of the care of the child. Also further find no provision or service or other arrangement is reasonably available to adequately safeguard the child. Relying on the roommates that don't have employment and aren't family members is not appropriate, and nor a long-term arrangement that would be able to support this request for placement with the mom, especially again in light of the comments made by her own parents that she needed their support in order to provide care for the older child that they then later adopted. For reasons I've already stated, I find continuing the child's residence in the home of the mother is contrary to the child's welfare. I do find further reasonable efforts were made to prevent or eliminate the need for removal, and that certainly comes as a result of the prenatal care advices of doctors and clearly your own support system by way of her parents that could have advised her, and she simply did not take the necessary measures that she needed to as a result of those services in order to make sure she was ready to take care of this child. And she certainly hasn't demonstrated those skills at this point. Conditions of the child away from the parent are adequate to safeguard the child's health and welfare. As a part of the placement with that putative relative, I will order DNA testing for both of our putative fathers that were named. I will also schedule a putative father hearing to take place in conjunction with our final pretrial prior to the bench trial. Final pretrial again will be October 1st at 9. And the bench trial set for October 11th at 10 a.m. Ms. Berger, are you available?
I will be available for the first, hopefully, Your Honor, and the 11th, if I'm not available, I'll have coverage secured.
Okay, all right, thank you.
Thank you.
Appreciate that. I've set aside the whole day on the 11th, but of course, given the professional witnesses that may be necessary, I'll rely on Ms. Thomas to let us know if she needs any additional time for that bench trial at our final pretrial, which again will be October 1st, 2024 at 9 a.m. Visitation will be as according to policy. And if I haven't said it already, the child is in the safest and least restrictive circumstances at this time. Any questions?
Was that 9 both days, Your Honor?
9 o'clock for the pretrial, 10 o'clock for the bench trial.
10 o'clock, thank you.
Thank you.